The Constitutional Court has handed down a landmark ruling affirming the rights of prisoners to use personal computers in their cells for educational purposes. The court suspended the declaration of constitutional invalidity for 1 year, directing the National Commission of Correctional Services to implement a revised policy. In the interim, inmates enrolled at recognized tertiary or further education institutions who reasonably require a computer for their studies may use personal devices in their cells, provided they do not have internet access. Well, joining us now is Nabeelah Mia, head of the Penal Reform and Detention Monitoring Program at Lawyers for Human Rights. Nabeelah, a very good afternoon to you. Thanks very much for your time. Were you surprised at all at this ruling?
Not per se surprised, given that historically the High Court has always actually found in favor, in most cases, of incarcerated students who've been trying to access their learning tools. And so we were grateful, our client was very grateful to reach this culmination of his journey fighting this issue.
Of course, I mean, I was looking at conversations on social media, people saying, well, we have a constitution here that is way too liberal for our own good. We should remember why these people are in jail in the first instance.
Sure. I think that the thing to recognize from this is that people who are incarcerated and want to learn and have access to tertiary education should be taken as a step that they want to, improve the lives, improve the background that they come from, so that when they are released, they're able to contribute towards society. And, the hope is that people recognize that as for what it is.
In fact, an important consideration, considering the fact that after all, it is as much about people being held responsible for their deeds as it is about ensuring that they do indeed reform and they become better people who have a positive contribution to make to society.
Exactly that. You touch on a good point about contribution towards society. People are incarcerated, and the crux of what our client was asking for is that he is incarcerated in his cell from 3 p.m. one day until 7 a.m. the next day. And you can imagine that amount of time sitting doing nothing. People like him want to use that time productively, so that when they are released, they can say that not only have I served my time while incarcerated, but I'm able to show how I've furthered myself and bettered myself for my community when I am released.
Of course, I mean, it reminds us again of why the department in the first instance decided on a blanket ban. Was it because they didn't give considerations to certain things, or was it because, or they just I don't know how else to put it, did they just took a shortcut?
I'd hate to say that it was the latter. Throughout the history of this legal matter and similar matters before it, the department has always said, oh, this is a security risk. This is going to lead to broader issues. And in every instance, the courts have invited the Department of Correctional Services to say, well, show us the security risk, give us the evidence of it. And the Department of Correctional Services has not been able to do that. Similarly, the courts have said, well, can you provide access for people, during the time that cells are open, to computer labs where they are able to complete their degrees under the supervision of correctional services officials? And again, similarly, as you might see from the judgment, access to computer labs, to learning materials were provided very sporadically. Access to the computer labs is very sporadic. It only takes place for 2 to 3 hours a day, which didn't allow people to actually complete the degrees that they needed to spend the time studying that they needed to do. And the department couldn't show why they provided this inconsistent access. And so with those things juxtaposed against each other, the policy itself just did not make sense. And I think, even if when we're talking about education even outside of prisons, we know that tertiary education has evolved in such a way that access to laptops or computers is actually something that most students at universities or at courses are required to have in some way or the other. And so if you're putting people in a position where they aren't able to do that, but they need to complete degrees, and it actually looks good for the department to have more people studying, you have to ask, why are they're not providing the means or the opportunities to do so? Because if you look at the percentage of people that are actually studying, it's quite small within the correctional centers. One would have expected it to be higher, but I suppose it's because of the hindrances that the department has put in people's ways that don't allow them more people to study.
And the department, that is, shouldn't or don't deserve the benefit of a doubt that perhaps they were trying to err on the side of caution, or they are careful not to open floodgates, for argument's sake, where this may well be an opportunity for other people who have all the wrong or bad intentions.
Sure. I mean, on that point, it goes back to my previous point of how the courts, this matter isn't one of its kind. This matter has been through different courts, and it's also been in different permutations where other incarcerated persons have gone to the courts to ask for access to their laptops to complete their degrees. And in about what, 9 or 10 cases, each time the Department of Correctional Services was asked by different judges, different courts, to show what is the security risk? Can you show it to us? So that, because we as the courts want to consider it, and they weren't able to provide the evidence that the court needed, which makes one wonder where that evidence is, number one. And then number two, if we're talking about erring on the side of cautions, we've seen in multiple instances the issue of cell phones being brought in by correctional services officials and contraband being brought in by correctional services officials. So the caution, I would say, in this instance was misplaced because there's no accountability for the other things that I've mentioned. And here you are targeting tertiary education students who want to use their time while incarcerated to, again, improve themselves, to show the nature of the rehabilitative process and how it can work. I mean, we've had clients who spent the time while incarcerated getting degrees, and when they're released, they're able to use those degrees to serve the communities that they're released into. So we know that actually, we've seen that model work from our side.
The judge who penned the ruling, of course, also saying that incarceration does not take away or limit fundamental rights like education, dignity, and access to reading material. Nabeelah Mia, thank you very much for your time, the head of the Penal Reform and Detention Monitoring Program at Lawyers for Human Rights.